Ready to go? Okay, call our regular meeting. Fine transition order. We'll go ahead and call roll. Good morning.
Here.
Manning here. David here. Mr. Hinckley is absent, and Mr. Platt is here. Two housekeeping items. Byrne is probably having had today surgery for detached retina, and that's why he's not here. I don't know for a fact that he had it, but he was probably going to have it today. And I believe that was discovered yesterday, might have been the day before, I might be getting it wrong. So there's emergency surgery, and yeah, he's not here. Maybe he's going to be online. I don't know, but I don't expect that. And then second, I don't know.
Surgery for what?
A detached retina.
Oh, ooh.
And then second, I don't know if all of you know it or not, but the Mitchell application has been pulled, so we will not be discussing that tonight.
Oh.
And for any of you online, if you're here for the Mitchell application, we won't be discussing it tonight. The application has been pulled. So with that, may I have a motion to approve the agenda?
So moved.
Is there a second?
I'll second, but I do have a request.
Sure.
Can we make a permanent change to our agenda to include a 10-minute break after the public hearing, and we go into our personal discussion? That'll make my life easier.
Let's discuss this after approval agenda, and yeah, let's do that. So any further discussion on approval agenda? Okay, all those in favor?
Aye.
Aye. That motion passes. Rob, I think for all of us, anytime anyone needs to be excused, I think we can take that. And I don't think we need to put on the agenda. I'll be happy to do that.
Well, I understand that, but I would prefer not to have to ask for a break. I would like it to be a permanent item, if
Okay.
possible.
Well, I tell you what, let's take that up at the end of the citizens conference.
Okay.
We'll discuss it. That'll be great. And maybe everyone's happy with that. So, all right. Approval of the minutes. May I have a motion to approve minutes for May 14th.
I move to approve minutes.
Is there a second?
I'll second.
Any further discussion?
I want to say that I have watched the discussion of the Mitchell application that you guys had. And I want to commend all of you for your thorough discussion again.
Yeah.
It was easy. Thank you, Joe. It was easy to find an appropriate section and then just listen to what you had to say. So I think this system works.
Any further discussion? All those in favor say aye.
Aye.
That motion carries. Disclosures, conflict of interest. Diana, you have anything?
Nope.
Maura?
Nope.
Rob?
I have forwarded the link to the recording of the meeting to a neighbor in Pilot Hill.
I think that's fine.
It's not a conflict of interest, but they were curious about the discussion, so I forwarded the recording.
And I don't have anything to disclose. So we will move on to our next item, Dunlap zoning district amendment, ZDA -04-25. Joe.
All right. The applicant and owner is Lance Dunlap. The address is 39 Peakview Road. The request is to change the zoning from agricultural to rural residential. There were some reviews. Most had no comments, but Holly Dyer from the Laramie Rivers Conservation District commented on erosion, soil degradation, and reclamation of disturbed areas. Her full comments can be seen in the review section. The applicant has provided a complete application, including all required documentation. The planning department believes that the proposed zoning district amendment generally follows the suggestions of the Albany County Comprehensive Plan. This property is currently zoned ag, and a change to rural residential is compatible with existing land use of surrounding properties. This property is going through the zoning district amendment process because the planning department has an open enforcement case for having two principal structures on an ag property of 38.85 acres, which does not meet the allowed density. The original enforcement case was opened in 2019, but the landowners were not willing to work with the county to fix the issues that are apparent. A new enforcement was opened in 2024 with a new landowner who is willing to work with the county to fix the issues. This application is the first step moving forward with the fixing the issues on the property. And there are a couple of options for the landowner to continue moving forward with either a subdivision or a conditional use application. The findings necessary for approval and applicant responses referenced in this report are adopted as findings reflecting that the applicant has adequately addressed the specified impacts, and the same are incorporated herein. The applicant is proceeding in accordance with and is in compliance with the requirements of the Albany County zoning resolution, and staff recommends approval of the Dunlap zoning district amendment application CDA 0425, adopting and incorporating the staff analysis, findings of fact, and conclusions of law as each are stated in the staff report.
Before we have any questions, I have one just sort of a question aside. Were any penalties ever actually assessed to the prior owner?
No.
Questions for staff?
I I don't understand what they're applying for exactly.
So there,
If
go
you
ahead.
can clarify, because you can build on agricultural land.
Right.
Do they want to add another house?
So currently, if you look at the aerial, there's two primary dwellings and then two like accessory buildings with each one.
Mhm.
And so it doesn't meet the density standard in order for that to be legal. For that to be legal, they would have to have 70 acres to meet the one dwelling per 35 acre density on ag. And they don't have that. So that's where this comes in. This would allow them to do it. And then there would have to be a follow-up application if this were to be approved. And they could either subdivide, like split it in half, or do a conditional use, which I believe that they plan on doing a conditional use, but obviously nothing is final. So
Gotcha.
I think that's what the plan is so far.
And so basically they want to take an illegal situation and turn it legal.
Correct.
And are they part of the area that they can only have 20 acres minimum?
They can have 10. That's the
Okay.
Wild Horse Ranch
That's, okay, right,
covenants.
all right.
Diana, Morrow?
I was gonna ask why they didn't just go for agricultural residential, but now they don't have quite 40 acres.
They don't have 40.
That's the reason.
Correct.
That's why they have to go down to rural.
Yep.
Yeah. And I wasn't clear what the two buildings are, but I think you already clarified that. One of them is labeled and one isn't on the site
Right.
plan.
Yep.
How did the lot to the north become ranchette? Because that's really dense, right?
Yeah, so that was changed in 2021, I want to say. That plan was that was back when it was called rural residential. And it was the big jump from ag to rural residential from 35 to 5 to 35. And that was changed in order to do a conditional use to do kind of the same thing. Cause I think they have a cabin. There's like a small cabin, but the landowner didn't want to use that cabin as the primary residence. But the way to do it was to change your zoning, get a conditional use and build a new house, however big you wanted. And then so they went through the zoning change, they did the conditional use, and then they never put the conditional use to use.
Oh, okay.
So that's now expired.
But it's still zoned ranchette, so they can go down to pretty small lots there.
They could, yeah.
Excuse me.
Well, sharpen my language, use Burns' language since he's not here. They could apply for a.
They would have to subdivide.
Right, yeah.
Okay, but they're zoned for it.
I'm only saying it because Burns' not here.
There won't be a need for a zoning change.
Okay, well, that's all I was wondering about.
Morrow?
Yeah, thank you, Mr. Chair. I just have general questions about enforcement and violation issues that you face. So because it seems like you were trying to address this since 2019, how many open enforcement cases do you guys have?
Last year we had about 75.
Oh, yeah.
And when I took over as the kind of supervisor to enforcement in May, and since that time we had like probably 60 to the end of the year. And then this year we're at about probably 12 so far.
So per year, or you've reduced it from 70 down to 12?
This year we've started 12 new ones.
Oh, okay.
And we were without an enforcement officer for 4 months.
So cumulatively, you have almost 200 enforcement?
Well, they're not all open. I'd say a majority of the ones last year are closed. There's still a few hanging around, but for the most part, they're closed. And then we have a few that's already been closed this year. So I don't know. I'd have to look at the database, but probably working on like 20 or 25.
Is your only recourse to apply penalties, or can you do things like put liens on a property? No liens.
Well, so the only path for enforcement is filing a complaint in district court and going, yeah, I mean, it's a full lawsuit. And then if you get a judgment from the district court, then you can enforce that judgment in a variety of ways, but you eventually have to, conclude a lawsuit with the district court first.
And as Matt will probably say, a resolution is always better than going to court and that kind of stuff.
Right,
So
yeah, no, getting voluntary compliance is for sure preferable, resource wise. And we appreciate Mr. Dunlap, working with you on trying to bring the site into compliance. So kudos to both of you. Okay, I just was generally
Sure.
wondering what kind of enforcement issues you have.
And I don't have anything, so is this app online or?
yeah, he's right there.
Are you Mr. Dunlap?
I'm Mr. Dunlap. Yep.
So is there anything you'd like to add to your application to address the commission with?
No, and I just want to thank Joe for his help and guidance through this process. This is obviously something that we're working through, and I appreciate every step of the way that he's been with us, and I appreciate everybody over there's understanding of us trying to bring this to compliance. This is a learning process for me, and I'm happy to comply and do every step along the way. So thank you all for your time.
Well, it certainly sounds like a potential win-win situation, and let's hope that's the way it goes.
Now, hopefully, so.
Yeah, so are there questions for the applicant? None? But that was easy then. Thank you for being available for questions.
Sure. Are we?
Or
do you want me to stay on here?
Well, I think we're done with your being here, but a question might come up, so that'll be fine. Discussion.
Joe, need to have a public hearing.
Yes. Are there members of the public who wish to speak on this matter? Hearing and seeing none, may I have a motion to close the public hearing?
I move to close the public hearing.
I'll second that.
Any further discussion? All those in favor, say aye.
Aye.
Public hearing is closed. Now we'll move on to discussion. Thank you. I'll just say that, I support this application. To me, I think we should move forward on this. And take the advice we've heard from both Joe and council that matter we can resolve this matter rather than going to the district court is a thing we want to do.
Mr. Chair, I'll move move for approval that we recommend the Board of County Commissioners approve the Dunlap zoning district amendment ZDA-04-25, adopting and incorporating the staff analysis, findings of fact, and conclusions of law as each are stated in the staff report.
I'll second that.
Any further discussion? We will vote. In that case, Diana,
Right?
Mauro,
Aye.
Ralph,
Aye.
and I vote aye. That's unanimous. The motion carries. Thank you.
Thank you, everyone.
Yep, thank you.
We will continue with citizen comments. I don't think we have any citizens who are going to be making comments. So we will go on to amendments to the planning and zoning commission bylaws. Matt has prepared a bylaw suggestion for us, which was in the packet.
Joe has.
So that's something, so.
Go ahead.
Did you want to discuss the break? I know you said you would do it at citizen comments. I don't know.
We can do it
No.
now. It doesn't really
It
matter.
doesn't matter. That's
I,
when it was said. So I don't.
I would like us to have built in, so we don't feel like we're in high school or middle school needing to ask to take a break. I think a 10-minute break. Today it's not a big deal because we're cruising through, but when we are in a 4-hour meeting, it would be nice to have the break after, as we transition from public hearings and the public involved to our own discussion. That is my reasoning for asking for this.
We could just have the chair make that judgment call if it's going to be a long meeting. Just have the chair keep that in mind, because we do sometimes have breaks. Somebody proposes it, right?
Yeah, because we ask for it. I would like it to
Or they
be,
ask us if we want.
I would like it to be an item in agenda that says break. 10 minutes. We can skip it if we don't need it, but that it will be built into the agenda.
Okay.
So do you want to move to add a permanent agenda item for a break in between the citizen comments and the current planning projects?
Yes.
Then I'll move, Mr. Chair, that we add a permanent agenda item. I don't think we have to do this in the bylaws, right? Because that's just, that's like a recommended
It's kind of like
agenda.
flipping the agenda like we have in the past.
Right,
where we
okay.
move
The agenda is set by
By
the chair.
Right. So I move to recommend that we add a permanent agenda item for a break between citizen comments. So we can let the citizens go before current planning projects.
I second the motion.
We will have further discussion. And I will begin the further discussion. How about if we put an item along these lines on the agenda where the chairman asks if anyone would like a break, and we do it that way. 10 minutes is a long time, I think, to allocate for every meeting. I mean, like this meeting, I think that might be just, how about that? How do people feel about that?
I don't think we need to be in high school. I think it should be a simple thing. And if nobody needs a break, we can ask you not to have the break.
So if it's on the agenda, I'm just trying to think how this would practically work. We citizen comments, and there would say, next on the agenda is a break. Do you need the break, or can we pass on the break? Is that essentially what?
That's what I'm suggesting. I would just say, would anyone like a break? If someone makes a signal, we have a break.
But if it's on the agenda, then your question is, does anybody need a break, or can we skip this?
I
Can
would
we
say,
skip the
would
break?
anyone like a break? That's what I would do. I'm opposed to allocating 10 minutes, a fixed amount of time for every meeting, without knowing in advance whether or not we're going to need it or not. I'm happy to have a break anytime anyone wants to. And I don't see it as being in any way demeaning or you know, to use your term, high schoolers or whatever, I mean, if I need to go to the bathroom right now, I just say, hey, we need to take a break.
You feel comfortable, I do not, and I'm asking that we avoid any incidents where I feel uncomfortable.
I mean, we can add like a wordage or something to just like ask the question or make sure that, you know, if there is a break that is needed, we can have it, like, just to put it on the front, like, in people's mind that it's there, you know?
Why is it so difficult?
It doesn't matter to me.
Why is it such a big deal to add the item break? You don't need to say 10 minutes, you say break.
Sure.
And that elicits the question, do we need a break?
Well, that's fine.
Yeah,
That's what
don't
it's
say
fine.
something.
I don't understand why this is becoming such a big issue when it's just to make everybody comfortable.
And I don't think we need to take a vote on that. I mean, we put this together and Joe, let's just do that.
Yeah.
And I'll ask.
There is a motion, so you can vote or not vote,
Well, that's correct. There is a
I can
motion.
withdraw my motion if it's already in the
It's already
chair's.
been seconded.
per-
Let's just
yeah.
vote.
Well, let's have a vote. All those in favor say aye.
I,
Okay, that carries and we will implement it as Joe will, in the future, add that item.
Sure,
Break after citizens' comments.
we can do that.
And we'll take care of it. And if I should overlook that, forget it, someone remind me. Very good. Thank you, Ross. So now we will move on to amendments to the planning and zoning commission bylaws. And looking at the red line version that you forwarded us and in the packet, Matt,
Yeah,
let me come to that.
that was just like the starting point, which I came up with during the last meeting.
Yeah, I understand.
So
I just want to clarify that in particular. Let's see what your intent was. So I'm going to read it. In the event of a tied vote on a motion to approve or deny a matter, the matter being voted on will be considered to be denied. So first of all, we make our decisions by motions. So when you say matter, did you mean motion or?
No,
something different?
the matter would be the item, essentially. Because that was already existing language in there, was for any matter to be in the preceding sentence. For any matter to be approved. Sorry, I lost it.
yeah, any matter to approve.
Oh, yeah, I was looking at the wrong one. So for any matter, a majority of votes shall be required to adopt any matter before the PZC. So the matter would just be the item.
And when you say denied, do you just mean that the matter or the motion doesn't pass?
No,
Okay,
it would be where it is deemed as a negative vote, essentially, no. It'd be deemed as if it's a negative motion has been adopted.
okay, that's what I want to clarify.
Yeah.
So it's
So,
recommending it in
With that clarification, now is there anything you'd like to say to all of us?
Oh, well.
Recommendations.
I mean, I guess I got some input from Byrne, sent me an email,
Right.
which he is not able to be here, but he has some good points, is that, you know, things need to findings of fact or conclusions of law would need to be supplied if denial is counter to a recommendation of the staff report. So that could get tricky. I did come up with a proposal which could address that, but it's also, I guess, in thinking about it more, It is really dependent on what the item is. So for example, like zoning district amendments or an amendment to the resolution, I mean, there's no time in which planning and zoning has to supply a decision. But there's a decent argument that anything for like an amendment to the zoning resolution or zoning district amendment, it has to be an affirmative recommendation to adopt it. Coming from planning and zoning. So that may need to be revisited in the past, if that issue were to be squarely decided. But then like conditional use permit, the statutory timeframe, since it's a zoning certificate, statute requires it to be acted on promptly. That's not a definitive time frame. Wind and solar energy permit. Statute doesn't even mention planning and zoning review recommendation. Our zoning resolution has planning and zoning review the application and make a recommendation to us, to the board. But then the board has timeframes where they have to hold a public hearing within 45 to 60 days of determining an application is complete. In which case planning and zoning would pretty much get one meeting to make a decision or a recommendation. Like you guys wouldn't be able to table it because the board has to have that public hearing within a time frame. Similarly with subdivision permit, it sort of already provides a default under statute. If no action is taken within 45 days of the Planning and Zoning Commission receiving a recommendation from DEQ or the date that DEQ's recommendation is due, it's deemed approved by Planning and Zoning. So I suppose there may not be a one-size-fits-all procedure for the effect of a tie vote. And ultimately, I suppose my recommendation to Planning and Zoning, which is not so much strictly based in statute, but based on sort of some overarching themes that I've seen in the past 2 years, is that application, particularly public applications from individual landowners, be decided on expeditiously. There was, I don't remember if it was last legislative session or the session before, but there was a bill that worked its way decently far through the legislative process where the counties and cities for any sort of like development permit, zoning certificate, XYZ, they have to like publish a schedule for time making or decision making. And if that is exceeded, the local government has to refund all fees associated with the application. So this is sort of, it's, being eyed. And I guess my recommendation is don't, I suppose, put a target on the county when there doesn't necessarily need to be one. So I guess, maybe there's a requirement that like an application or a public application, such as like for a conditional use permit, individual, so adjudicative zoning district amendment, those sorts of things, that it be not, tabled or continued for more than one meeting. I'm not sure if that needs to be explicitly said. And I guess, I don't know. Maybe it doesn't need to be addressed as explicitly, but I thought that it was at least at the time, I felt like something that might want to be considered. And I don't know if that feeling has changed, but.
Would y'all object to my going first on this? Yeah. Okay, well, there's obviously a reason why we are 5 people, county commission's 3, so we don't have tie votes. In the time, this first time I taught it was to me. I believe strongly that we should endeavor to have a vote which decides the matter and not rely on a tie vote. And if that means voting again at the next meeting, whatnot, so be it. We could schedule special meetings if we were to arrive at a tie vote. And I think we ought to provide an affirmative recommendation by voting to the county commissioners. I think that's our job. And not to default to a tie vote should that occur. And then finally, as a chairman, I vote last on all these things. I can ensure we don't have a tie vote if necessary. So with that, your thoughts, please, all three of you.
I have one question from that, because Moira's motion was to deny,
Mhm.
and then there was a tie vote. That means if we follow your wording, that means that her motion failed. Is that right? So that's, I guess it goes back to the question of a motion versus a matter.
Yeah. So, and actually, Joe, I just sent an email. Would you be able to throw up that document? No, so I guess like what I was trying to say with sort of incorporating like the existing language is that the matter is denied. So that's kind of irrespective of the motion to deny or a motion to approve. If there's a tie vote either way, whether it's motion to approve or motion to deny, then it just kicks to the matter is denied. So
The matter is denied
yeah.
and not tabled.
Yeah, and I came up with some language this afternoon while thinking about what Michael and Byrne said a little bit more, and I think that this would be a much more restrained or like reasonable option, because there is potentially a scenario where a decision has to be made at that meeting and it can't be tabled anymore. In which case, I mean, I would say that if you can't affirmatively approve something, then the effect is essentially denial. And if an affirmative approval requires a majority vote to approve.
Am I looking for a red line or?
Yeah. Oh, did I?
I like this.
Page 4.
Oh, darn it. I think I'm sorry, Jen. I sent the wrong. Yeah. Sorry, Joe. I'm sending a different one.
Okay. Is it the 611 one?
Yeah. Yeah, there we go. Okay. So it would be unless permitted to continue consideration.
Scroll up a tiny bit more, then it will be easier to see. Thank you.
Yep.
So just for clarification, when you say denial of the matter, we're recommending, the recommendation that goes up to the Board of County Commissioners is to deny the matter.
Mm-hmm. Because my logic is that there couldn't have been a affirmative motion to approve.
So whether the motion is to approve something and you get a tie, or the motion is to deny something and you get a tie, or the motion is to table something and you get a tie.
Oh, this wouldn't even cover that. This is only a motion to approve or deny a matter. So if it's a tie on a table, that would be something else entirely.
I just brought that one in because that's, that's what we get for our options in the packet
Yeah,
for any application is approve, deny, table. And in the rare instance when we're not all here and not all reaching consensus, we could tie on any one of those options. And this would say that results in recommending a denial.
if you tied on the table, well, then yeah, you'd probably also then tie on then it would have to go to approve or deny. You'd have to move to decide it then. And then that would probably also result in a tie, which then I guess kicks you into here.
Because I mean, the whole idea is that you're keeping something moving forward to the Board of County Commissioners, who are the ultimate deciders. And then we don't slow down a process for somebody.
Yeah. But I did add, unless permitted to continue consideration of a matter to a later meeting. So this would only kick in if you do have a time frame where it can't be tabled any further.
You can't hold something back.
Yeah, I think so far, this is a solution in search of a problem. This has only come up once.
Well,
If
so
we
it is a problem.
If it were the case that we had something that could not be postponed again, another meeting, then that could be identified and we could deal with it. Like I said, if I vote last, I'm prepared to make sure.
Which is fine.
Yeah, I don't like that. Yeah, I don't think you should change your vote to avoid.
I'm talking about casting it.
Right, but your vote would depend.
But they're
on-
saying like, if you were gonna tie it, they don't want you to feel bad and vote with two
Against
others
your
just to avoid a
conscience.
tie.
No, I don't feel bad at all. And then we could have put a note, in a case where there was a recommendation, but the vote was going another way than I felt. We could have pinned my comments that I was actually in favor, but that I cast my vote in order to move the matter forward.
I think that, the county commissioners would be aware that there was a tie. And they would watch our discussion and they would figure it out.
So they would hear my points of view. They would, I would be able to make my points and still vote the other way.
So even if it did let a tie be a negative resolution of the matter, they would know that.
Yeah,
That's how we got to that. And they would realize there was stuff to look at there.
because it's under 18.
I don't think it would be the worst thing to do that.
Well, it's not the worst thing, but I mean, it's simpler. We don't have to change our bylaws.
Well, I'm in favor of just making the change to the bylaws because that outlives our participation on this commission. And it's there for maybe a future chair doesn't wanna take your approach. It just makes it clear
Clarifies it, yeah.
how it would go. And I don't see it. Because our bylaw change stops with us or it has to go to the county commission.
It stops with you.
So we could just resolve it tonight and be.
Well, it would need to go through Administrative Procedure Act.
Oh,
So notice of consideration and 45 days of public review period. Because this would affect,
yeah,
the public.
right,
Yeah.
okay.
And it's essential, like with zoning district amendments particularly, since we are treating that as a recommendation to change the zoning based upon the comprehensive plan under 185202, there has to be a recommendation from planning and zoning. A lack of recommendation one way or another because of a tie, that would get overturned if, I guess, whatever the commissioner's ultimate decision was, if that were to get appealed to the courts, that would get overturned probably 95 out of 100 times.
Again, I will point out the other alternative to not change the bylaws is again, to just have another vote at the next meeting or schedule a special meeting.
That idea I like.
And well, I mean, if we want to go this route and change bylaws, I don't have a problem with that. I think this is a simpler solution though. And if we schedule a special meeting, have one vote on one matter, that can be done very expeditiously.
Yes.
I don't have to spend 5 hours doing whatnot.
Could it be? So, I mean, just planning and zoning meets once a month. Be that a special meeting is to be scheduled prior to the next regular meeting?
Well, yeah, I would say, yeah.
I mean, but there could be a case where there's a vacancy on this commission, right? And then
Yes.
that wouldn't
Well-
help because until the vacancy is filled.
Technically, the vacancy doesn't occur until your successor is appointed. So if you if you're over your term, you're technically, until I guess the commissioners have appointed someone, you're still serving.
Yeah, but you can have a medical emergency.
No, I know.
I mean, I
Yeah.
like the idea, as Maura suggested, of
That's true.
codifying this into the bylaws, because we are not permanent members of the Planning and Zoning Commission.
Hmm.
We serve a term. We have certain interactions, certain personalities, certain whatever. This can change like this, okay? It may be totally different people in 5 months. If this is not codified, you'll have to go through this again. If we identify a problem with our procedures, it's nice to identify them, find a solution for them, and codify that. That's my.
I agree.
It seems like if you take the choice of having special meetings, I mean, either we get the public notice over now for a one-time thing and we have a way to dispense with these in the future, or you're gonna be potentially like repetitively having to schedule and public notice special meetings.
Well-
Which is the greater burden on administrative staff?
You don't actually have to give any particularized public notice for a special meeting, unless someone has requested prior notice of it. The notice required under statute for a special meeting is the chair to the members.
Because it seems like
Yeah.
when we were doing all those special meetings, I thought we
We
had.
had-
Well, that's because there were statutorily required public hearings.
Oh,
So we were noticing the hearing, not the meeting itself.
oh, okay.
I know, it's,
That's always something.
yeah.
But let's learn from what is happening in the courts right now, where, we didn't have a deadline of submission of comments. That we fixed later, and that now we have to, when things are set in stone and written like this, whatever version, then you don't have these problems.
Yeah, and I mean, it hasn't happened on a subdivision permit, but I think that this is less disingenuous than to say, because a tie vote, which nothing can go forward, that's no action under statute that's deemed approved. This would essentially create an action, but it's not necessarily. I mean, I don't know. I guess it was asked whether the bylaws addressed that issue. And I was like, they should. And then I saw that they didn't. So I thought they can, and offered this and asked if he wanted to consider it. I'm not married to anything.
I think it should be in the bylaws. That's my opinion.
Yep, I agree.
Because we are transients.
I mean,
And I don't
Mr.
strongly
Chair.
oppose, but I do think that if we have a tie vote, it's because there's a member absent.
yeah,
And I think our job is to provide an affirmative decision. And if that means waiting a meeting before we have a quorum or all of us get together, then that's what I would favor.
Mr. Chair,
Yeah.
I guess like my latter language is still gonna allow the any special meeting or even tabling to the next public meeting or regular meeting. This would only kick in if you were to have to make an action one way or another right then.
So y'all seem generally in favor of this. So how about some specific language we can vote on? I'm gonna let y'all do it since I want to do something else. How about that?
I move we amend the,
It would, sorry,
oh,
Commissioner Hanning, the motion right now would be move to, publish and set public hearing on this for August.
13th.
Yeah.
And you can put a deadline of August 6th on public comment.
okay.
We have that room to do it.
Okay, then I move we set a public hearing and public notice with comments due by
August 6th.
August 6th.
Yeah.
To incorporate the second round of language that you prepared for the bylaws.
Okay, second. Okay, we're clear what we're voting on? All those in favor say aye.
Aye.
That motion carries. Thank you, Matt. Citizens. We're not. No, that's what they said.
Can I, is that commissioner comments afterwards? Yeah. No, go ahead.
Yeah, so there's not a whole lot of staff updates. David just wanted me to pass on that we are still working on, me and David and Matt and Jake are still working on the subdivision resolution. Hopefully have that to you soon, but
Is anyone like good at road engineering?
You asked us that before. and
Okay, now,
We don't have any,
Michael, weren't you Army Corps of Engineers?
I have some past in road engineering. It's a long time ago.
Okay,
If you have some specific questions, you can always ask.
okay.
and Jake isn't able to. Roads are not his.
No, they are.
Or,
No, they very much so are. It's just, yes, more hands.
right. And are you allowed to seek input from like volunteer people
Yeah.
out there? I can ask around. Cause it's just to review specs that would go in the subdivision regs.
Like standards for road construction and design.
Yeah, I could sort of look at anything y'all, about to come up with and give you what I think.
Okay.
And if I don't know something, then I'll just say, oh, I'm sorry, I don't know that.
Yeah.
Well, steer you wrong.
sounds like a deal.
I might not necessarily steer you right either.
Would YDOT, would Mr. McCourt weigh in on any of that?
I think it's that like YDOT standards would be overkill because those are always going to be highways.
But maybe he just has a good grasp of roads. I don't know.
Maybe so.
It's
Taylor McCourt is.
yeah.
I don't know, just throwing.
I'm assuming that he's busy too, and like
Right.
everyone is. So. I don't know.
And I don't think that for like a county road, which is not, because if it's a county highway, then that gets taken over by road and bridge, and it's not an issue.
But if it's a subdivision road,
That's privately maintained,
right?
a different story.
Well, I bet, and you can look all around the county at unhappy homeowner associations dealing with poorly designed roads that then they're nickel and diming to maintain year after year after year. So yeah, it matters, and seems like a reasonable burden to put on a subdivider instead of leaving it for the community to have to clean up constantly.
I'll be happy to take a look at anything you'll have.
Okay.
Commissioner comments?
Can I? Okay. Matt, it's a question for you, largely stemming from my ignorance. Can you prepare for next meeting a summary of what is the legal status of platted roads? And what is an easement compared, what are the differences between the two?
I mean, I can tell you off the top of my head right now.
Okay, perfect.
Is it?
Go ahead.
Okay. Okay, so there, it's a very actually old body of law. Well, okay, let's go back very far. Common law, so prior to statutes, judicially created law, a lot of it was borrowed from England. And there are courts of equity. At common law, a dedication of a road, so when you platted something, that unless anything was said otherwise, by the language of the plat or by sort of corollary evidence, it was deemed to be dedicated for public use, but ownership of the road and the surface estate still sort of was retained by the underlying landowners or adjacent landowners. And it was essentially just a public easement. Then we had in most states, I don't know, I guess any of them don't, just what's called statutory dedication. So dedication of a plat pursuant to statute, which in our and for Wyoming is 34-14-103. Number could be wrong, but it's in 34. It's under property conveyances, subdivision platting and recording. There it says essentially that I can find this very quickly. It says that the acknowledgement and recording of such plat for a subdivision of more than 3 or more lots is equivalent to a deed in fee simple of such portions of the premises platted as is on such plat set apart for streets or other public use, or is thereon dedicated to charitable, religious, or educational purposes. So in the sort of scant lines of Wyoming Supreme Court, construing that over the decades, I mean, I think this was 1880 when that statute was adopted, probably borrowed from Iowa. We borrowed a lot of our early statutes from Iowa. I don't know why. Well, I guess I was kind of on the trail. They initially said that there was a transfer of a fee simple determinable title interest, which is something a little less than a fee simple absolute, but it's still an interest in title of those portions which are dedicated for public use. And that was to the local municipality. So the county, if it's unincorporated, the municipality or the city or town, if it's within incorporated limits. That got lessened a little bit because
Sorry, Matt.
yeah.
Can you translate that into simple English for me?
Yeah. So essentially it was a title vested in the county or town or city. When a road was dedicated or was platted. And it wasn't expressly reserved for private use only. Cause there's,
So who has the title for that?
yeah, that's what I was trying to get to. So that, under some like old 60, 70 cases, the county or the municipality did, the local government did. Then local governments, actually the city of Laramie, started to try to sell those as if they like had full ownership of them. Courts didn't like that because it's a little bogus. And the court softened those holdings a little bit and said, essentially, the local government is holding title in trust for public usage. So who has title?
Who owns the land?
The public,
Public owns the land.
sort of.
So the landowner basically, it's like you confiscated the land from the landowner.
It's not confiscation though. It's not at all. They voluntarily gave it. They dedicated it to public use by platting. And that's not a requirement. They could have said, which
No,
we
they
see,
could have said no.
they could have reserved it for private ingress and egress only.
So didn't the Aliquot subdivision do that?
No.
In Sunset Acres, it all says private roads when you enter the subdivision.
Oh,
Well, what does the plat say?
yeah. So, and then that's another thing throughout the county, which is an issue. I don't know exactly who is responsible for it, but there are signs where it says private road, and it was very clearly dedicated for public use on the plat.
Yeah, Diana, those are definitely public roads, even though those signs are there.
What was the subdivision?
Aliquot.
Sunset Acres? And well, Aliquot, I thought would assume.
Yeah, before I went out there, prior, I was looking at Mitchell, the first thing, just to bike out there. I was gonna go in, I saw those private signs. I thought, well, I better not go in there.
Now, yeah, I
When I
mean,
went back home, I checked the landownership, yeah, public land.
But it's maintained by the
But it's
residents.
maintained privately.
yep. So
Privately maintained public roads.
So you
privately,
get all the responsibility and none of the privileges of owning it.
yeah. So there's essentially, one case from the 80s where the Supreme Court justice was dissenting, and he was advocating that unless the government actually takes responsibility for maintenance, they shouldn't have any interest in it whatsoever, and it should be private.
Right.
But that has not been authoritatively adopted by the majority of the Wyoming Supreme Court. I would guess that if this issue came up squarely again, they would probably go that way.
Yeah,
But I'm telling you what it is right now from the best of my research. And that Supreme Court justice said that all of the case law in Wyoming offers something less than a pictorial jigsaw puzzle of what is the status of these. But for this moment in time, they pretty much most of the subdivision roads throughout the entire county are publicly dedicated. So they're dedicated to public use. They can't exclude the public from using them, but they are privately maintained.
And that's regardless of whether it's a easement versus a right of way.
So yeah, because the effect is you can say whatever you want. It is on a map, on a plat. You can call it an easement. You can call it a right of way. I think it's all right of ways are easements, but not all easements are right of ways. Like square versus rectangle.
Like saying it, all right of ways are easements.
But not all easements are right of ways.
So an easement can be private.
Yeah, absolutely. Yeah. And in
So
the
maybe
plats,
that's what it is there.
what's that?
So maybe that's what it is in Sunset Acres.
It could be. I don't know the plat. I know of a few north where it says all roads shown on are private easements for the ingress and egress of the property are owners of lots shown on this plat. That makes it a completely private road. And then they would have the right to exclude people from using them. But it's unless the county actually accepts and establishes those roads as county highways, because any road maintained by the county under statute is called a county highway, then it's not publicly maintained. But it still has been dedicated for public usage, and the county is essentially holding those, the title for those roads, which is a little lesser of a title interest. It's a fee simple absolute determinable, or not a fee simple absolute, fee simple determinable. County is like holding those in trust for public usage. So.
Okay, I understand better. I have a question, a legal question now. Moira comes into town, she wants to buy a parcel of land. She looks at one, she likes it. It says on the county assessor that it is 20 acres in size, and she buys it. There's 20 acres, and she pays taxes on it as 20 acres. Okay? It is part of it is a platted road. Can she sue the county assessor's office for overcharging her taxes?
So, Commissioner Ben David, with all respect, I'm not gonna entertain this topic. That is well outside the purview of planning and zoning, and essentially interferes with my representation of the assessor.
Gotcha.
A well-crafted answer.
Thank you.
Any further comments? In that case,
Mr. Chair,
oh, you do have a further comment.
I have a comment.
Excellent. Wow. Go ahead.
I've been wondering if I took a stab at adding to the definition of small lot residential of all our land use or our zoning district sizes, that's the only one that is lacking more definition to it, in terms of like urban residential is tied to utilities.
Yeah.
And small lot residential is just sort of hanging out there without any expectation for the eventuality of utilities. Like it's a density that we have in our county where it exists, we see groundwater contamination from the density of septic tank leach fields. So it's not a desired density in places where you will never have hope of running utilities out to it. And so I was wondering if there would be support for adding to the definition of small lot residential such that it's within some radius of existing utilities, because then there's a greater hope that, as growth happens, that could eventually be added to a utility, as opposed to finding small lot residential areas that are far, far away from utility and will just be in an endless process of just contaminating their own water supply, and people having to drill deeper wells and all that results in. So I just wondered if there'd be support for just adding something to that definition that is like based on that they're appropriately located X distance from an incorporated area or an area that has a utility. Because I guess Centennial isn't incorporated, but they have a utility.
And we have utilities going down to 7.
Right.
What's the so is that
What?
is ranch had smaller residential?
No, they both have 2-acre minimum lot sizes.
But small lot has to average 2, ranch has to average 5.
Right.
No,
The minimum lot size is the same for both.
Right.
but I mean, it's with that average, you're not gonna get. The average, I mean, the lot sizes are gonna be a lot closer to 5 than 2.
Well, it depends on what I subdivide.
For
Yeah.
the ranchette.
No, for small lot rural residential, unless they're setting apart like a
Small
major
lot
chunk of land.
Small lot has the average 2.
But small lots averages 2,
Yeah, minimum
Yeah.
2, average 2.
and ranchette is
Minimum
average
2,
5.
average 5.
Oh, okay, never mind.
And Laura, I would say work with staff if you have proposition you like to develop.
Yeah, I guess I can just
It sounds like an attempt to do something positive.
try something and see what happens or not. So like I should just reach out to you guys with potential language and
Are you talking for the purpose statement, I'm assuming?
Or like how urban residential has like density.
Yeah, yeah. Like, let me share it.
thanks.
You're talking this
So,
right here.
also like when you go to urban residential, there's
Right.
more to the purpose.
And then,
And
up
when
here,
you
the
go
same
to
thing.
ranchette, there's more to the purpose.
right,
But small lot residential isn't very well defined. And it's, to me, based on what we see in the county with lots that size that are served by septic tank leach fields and private wells, it's not an appropriate density if there's no hope of ever having utility come your way. In the eventuality that you contaminate the aquifer that you're also pulling water out of with your private well. Like it's not a density that I think belongs in, as you all know, in the growth PG3s, PG growth area, I guess PGA, I'm using my acronyms. It's not appropriate for PGA3s in my view, because they're all far away from utilities.
Where would you draw the line of density? With your
Um,
acreage?
I guess I'd put it somewhere in maybe the Laramie growth area.
No, I'm talking an acre.
Oh, Well, I think what you see frankly is like typically prevent contaminating your neighbors with your septic.
Is there, do you have,
There isn't
Literature?
like some explicit study.
yeah,
There's like tons of studies where you can say, oh, look at the density in this subdivision here, all over the country and the world, and you'll see contamination. But nobody has then said definitively, like,
well, and what's the contamination? Is that like exceeding the EPA,
yeah, exceeding the
the 10?
10 milligrams per liter. Yep. I mean, that's what we see in Sherman Hills and Laramie Plains subdivision.
Those things are quite site specific, aren't they, depending on how much underground water flow you have?
Yeah.
Well, I mean,
Or
it can
the distance.
matter, like, if you're in the Jackson Hole area where their level of rainfall and flux of water is so high that you might not see that problem as much, but then you go to Hoback Junction and lo and behold, you got groundwater contamination from septic tank
I was
leach
actually thinking
fields.
more of the county, but.
Oh, in the county,
I was just thinking there are places where there's a lot of water flowing underground and other places where there's very little.
That's why
Or
I'm
it's
all
like incredibly
deliberating.
deep, right?
well, I think,
Cause you could, like, I mean, Wild Horse could hit like a decent well water, they would just have to drill really, really far, right?
Well, now, I'm just talking about where,
Yeah,
you know, it's.
right, yeah,
sort of-
no, you're
sort of
right,
areas.
that your chance of infiltrating down, if you're going to 500 feet to find water, your chance of infiltration all the way down to 500 feet would take a long time. It would take decades to get there. So I guess you're right, there are situations where where you might not see that, but still, I mean, are there other reasons to not want to see that density out at someplace like Wild Horse Ranch? I mean, not just the,
Oh, yeah. No, I was just using them as an example, because like they don't have good groundwater.
right,
That is easily tappable, is my understanding.
yeah, no, you're correct about that. So maybe I'm focused on one aspect, one of the downsides of that density of housing, but there could be, somebody might look at it also from like the noise and the visual and all the things that come with higher density housing out in more rural areas. Light pollution. Right.
Well, yeah, I mean, there's
Wildlife, any.
like Lincoln County has it's part of their subdivision resolution, interestingly. But when I looked at it probably like 2 years ago, they had explicit standards, like they were saying, if you're going to this zoning district, if you're creating a subdivision that's going to this zoning district, here is your requirement for wastewater. So like for something like small lot residential, it might say you have to have enhanced. I mean, I guess like the authority behind that is not firmly, is unanswered still in Wyoming, but
So they have specific zoning regulations for part of the county?
no, so it's a function of subdivision. Which is
Depending on the number of lots and how small they
they're
are.
saying, yeah, they're saying if your subdivision is in this zoning district, this is the system that we're gonna require for your subdivision. So like, urban residential or something very small, they're gonna say like, you need centralized. Those little more like kind of intermediate or, well, smaller, but still, couple acres, they say enhanced, and then as you get bigger, it can be septic or conventional, sorry.
Okay, well, I'll see what I can.
I mean, and I think similar to my advice with, APOZ is that like it should be more of a function of either the wastewater regs, and then there is, I think, a decent argument of going like the Lincoln County route and making it a function of new subdivision.
As opposed to making it a function of zoning district amendment.
Well, it would, I mean, likely fall in line with zoning district amendment. I guess, because, that usually precedes a subdivision, but if you put it just on subdivision, then it hits that I guess, regardless. Unless you also make it a function of, you could kind of take urban residential as a model where it's like, if you want to get down to 2 acres, then it requires enhanced or something. I guess like more of an incentivized system rather than imposed. I don't know. I guess I'd recommend that you planning and I talk about any idea you might have.
Could be done there, yeah. Okay, thank you.
Yeah.
That's all I have, Mr. Chair.
All right. Well, in that case, our next regular meeting is July 9th, 5 PM here.